This is Michael Popok, Legal AF. We got a major development with a new decision at the D.C. Court of Appeals in a 2-1 decision that's going to lead to a number of Jan 6 defendants already convicted and sentenced having their sentences vacated, overturned, maybe let out of prison or probation, depending upon how much time has gone by, and then resentenced under the new rule that was just passed 2-1 by the D.C. Court of Appeals. What am I talking about? Right below the really bad people that committed all the felonies and are going away for between 5 and 18 years. And now in the case of the Proud Boys, the federal government, Department of Justice, asking for up to 33 years. There's a group right below them that contributed to the overthrow of the Capitol, to the outmatching of the Capitol Police and the DC Police, right? That helped strain resources and the allocation of resources so that people could break in and break through, right? Cause carnage. The trespassers had a role, right? It's like the players or the chorus in an opera or in a play. They may not have a leading role, they may not have a speaking role, but they're up on the stage and they're important. They're in the chorus. Right? And so these people, they were convicted of a crime, but the crime was a felony level. A misdemeanor level, which put them at, a year or less. But since the year or less wasn't going to be a long enough time to keep them off the streets for the next election, many judges gave them a combination of sentences in jail, 6 months, 8 months, up to a year, and then a period of probation. It's referred to as a split sentence. It's done all the time in the state court system. And since 1994 and some criminal reform law that was passed by the then Congress when Bill Clinton was in office, most judges have assumed they have the power to both do a prison sentence and to have supervised release and probation. Not anymore, not according to the D.C. Circuit Court. 2 judges of that circuit court, because you have a 3-judge panel for appeals. That's all you get. If you don't like that, next stop, U.S. Supreme Court, if they take the case. This was an interesting combination of 2 judges that ruled that their sentences for these misdemeanor people, the people who got probation plus time in prison, in order to stretch them out beyond the next election, that the judges overstepped their authority. And that they're not allowed to do that. They can either give a sentence or they can do probation, but they can't do both. It's one or the other, which was news to most federal judges because they've been doing this since 1994. So Justin Walker, who's a D.C. Court of Appeals justice appointed by Donald Trump, clerked for Brett Kavanaugh. Not only that, he went on television over 140 times defending Brett Kavanaugh during the confirmation process because he was a former clerk. He's written articles in which he suggested that the FBI is a weapon of whoever's sitting in the presidency, in this case Donald Trump, and should be properly used that way. Put that all aside, his jurisprudence and judgment aside for a minute. He's one judge. He needs another judge in order to vacate these sentences, overturn these sentences, and either release these people from jail right now or have them resentenced by the judges. Doesn't mean they're innocent. It just means their sentences have to be adjusted and compensated for. But the second judge that joined Justice Walker is Judith Rogers. Judith Rogers was appointed by Bill Clinton. She knows better. She knows what Clinton and the House was trying to do then in the 1994 Reform Act. She's been a judge since basically that time. And so she sided with Justin Walker and said, yes, it can only be probation or a prison sentence, but it can't be both. The judge overstepped his boundaries. Your pet's a member of the family. My Lily certainly is. Don't feed them like they're in the doghouse. Give them Nom Nom. Nom Nom delivers fresh dog food with every portion personalized to your dog's needs, so you can bring out their best. Nom Nom is made with real whole food you can see and recognize, without any additives or fillers that contribute to bloating and low energy. That's because Nom Nom uses the latest science and insights to make real good food for your dogs. Their nutrient-packed recipes are crafted by board-certified veterinary nutritionists, made fresh and shipped free to your door. Nom Nom's already delivered over 40 million meals to good dogs like yours, inspiring millions of clean bowls and tail wags. I love my dog so much and feel better giving her better nutrition. And my dog loves the food and other benefits they've seen. Plus, Nom Nom comes with a money-back guarantee. If your dog's tail isn't wagging within 30 days, Nom Nom will refund your first order. No fillers, no nonsense, just Nom Nom. Go right now for 50% off your no-risk 2-week trial at trynom.com/legalaf. Spelled try, NOM.com/legalaf for 50% off. Trynom.com/legalaf. Now, there was a dissent. Judge Wilkins, who was appointed by Barack Obama, dissented and said that's exactly what the 1994 statute said. It gave the judges the discretion and the authority to do a split sentence if the facts supported it. I mean, for the person that they're debating over, they're making new law, you might be saying, well, who are we talking about? There's a guy named James Little. James Little was convicted of criminal trespass because he wouldn't leave, right? And like I said before, there's no small players, only small actors. He had a role, even though he didn't pick up the police shield and beat people, use bear spray, use his bare hand, his fist, flagpole, but he was there. And he was in places he shouldn't be, and he was part of the mob that was overrunning the Capitol. And so Judge Royce Lamperth, who was a Republican appointed judge, wanted him off the street. And so he said, sure, I'm going to give you not 11 months in jail, but you're on probation through and after the next election. And that's where the judges in the D.C. Circuit Court of Appeals said you went too far. You can give him jail, which would be this is a misdemeanor. You can't give him that long. It's up to a year in most circumstances. Or you can give him probation, but you can't do both. And since they already served the prison sentence, because most of these people already went away, they're going to get let off of probation because you can give only one. And if the judge gave him prison and he's not allowed to give him probation, the resentencing is going to be removing the probation, meaning when this person leaves or he's already left, he's off of probation and there's no control by the federal judge. Now, if he commits another crime, of course, between now and then, but we won't know it. If there's another Jan 6th or a November 2nd or a December whatever, leading into the next election, he'll just commit a new crime. Now, of course, he'll have a higher criminal background, a higher criminal behavioral count for future sentencing, but he'll be on the street. So that's what's going to happen now. There's a group of misdemeanor-only Jan 6 defendants that, based on this new decision, are going to be sprung from jail, right? If they're out already, their probation is going to be eliminated. If they're awaiting going into the system, the judge is going to have to make a choice, jail or probation. Pick one. And the judge is going to either say, oh, you didn't go in yet, I'm taking away your sentence. And if they've already served their time, they're off of probation. So this is the development. You got that level, right, where the Department of Justice is seeking 5, 8, 18, 33 years for the bad people, the leaders, the seditious conspirators. But that other group, right, that makes up the bulk, right, the bulk of the 2,000 people or more that attacked the Capitol, they shouldn't be able to have no repercussion having served their time. And so this is the development that we've seen. Now, if the Department of Justice doesn't like the result, and I don't think they will, they'll take an appeal to the Supreme Court, and we'll see what the Supreme Court does next when it comes to law and order about the 1994 Act that was being interpreted by Justice Walker and Rogers, I believe, improperly. I'll bring hot takes just like this one so you know about Jan 6 defendants that are going to be off probation and wandering the streets with free liberty right before the next election on hot takes like this one on the free MeidasTouch YouTube channel. Subscribe to their YouTube channel. You'll get content like this one and lots of other stuff, and they're trying to get to 2 million subscribers, and it's all free. We also have a podcast on the MeidasTouch network that are just like these hot takes, except we got 2 other anchors along with me, and we put it all together in a show we call Legal AF. AF at that intersection of U.S. law and politics. Go on the MeidasTouch.com website. You'll see contributors like me, all my hot takes, the website content, which is, they basically have a newsroom that's writing at the intersection of law and politics, and all of our videos, right? Our hot takes and podcasts, all there on the website. You like what I'm doing? Give me a thumbs up here. It helps with that algorithm. And you can follow me on all things social media and the Legal AF podcast at MS Popok. Until the next hot take, this is Michael Popok, Legal AF.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.